she's taking the matter to court. Yeah. They haven't finished, and yet they've removed her. Yeah. So in a sense, we can blame you because you've provided the legal and the social capital for such a thing to happen.
So let's be clear. I mean, I've said, particularly in connection with the removal of the current Chief Justice, that it is not part of the reform of the judiciary. And I've heard so many times when I've talked about this, people say, but the CJ is being removed. If you think that the beast of what our judiciary is, and its dysfunction is linked to just one individual, then you have misappreciated the scale of the problem. Now, as far as the judiciary is concerned, I do think that there's a way in which we can have the conversation about judicial accountability and also ensure that capture or executive control can be limited. But it's not impossible. There's no office in this country that is out limits from how the politics functions. I don't think there's anyone. There's nobody in the judiciary. As long as the executive is set on something, they'll get it done. You know? And I mean, even as somebody who was defending petitioners, in this case, I'm very interested in due process and the rule of law. But I also understand the politics of how this country functions. There are certain games that the executive would not play unless it was assured that it was going to win. I believe that sincerely.
But can we not say you've enabled an injustice? Because, for example, we're told that the procedures were not... I mean, look, Aikoto wrote a long letter today, almost 6 pages. He alleges suppression of exculpatory evidence. He speaks of procedural violations and denial of due process. He speaks of pending judicial review and active litigation. He speaks of Community Court of Justice, ECOWAS. And then he talks about non-availability of committees report. Basically, it's like the woman's rights have been violated, and because we are baying for blood, we are prepared to close our eyes to all those violations just because the judiciary is not fit for purpose, and maybe we don't like the former CJ.
So, you know, there's one of the ways in which you repeat something over and over again, it becomes to sound like the truth. The truth is, I can be able to understand the politics. That is a political body language of the executive that wanted to remove the Chief Justice. I can admit that. But I can also say that in terms of the process and the proceedings I was a part of, that all and several of these allegations were completely inaccurate. Now, I don't agree in terms of our in-camera proceedings to extend it to say that post-committee reports should not be released. And I've said this consistently. In fact, in the question of, we had petitioned for the removal of Jean Mensah over SAL, and one of the big things we kept disputing was that the public have a right to know about what is going on. Even if the proceedings itself can be kept secret, the fact that the petition has been brought against the Chief Justice, the public have a right to know. The fact after, and the reasons why they were removed, the public must know. So those debates about how the level of transparency and information that can be provided is a conversation that we can have a healthy debate about. But it doesn't necessarily invalidate whether or not mechanisms were put in place for her to be able to receive justice. To do so would be is to deny the proceedings that I was part of and the level of accommodation that was given to her in those proceedings.
But do you not think that the fact that there are still active cases, the president ought to have waited for those cases to be dispensed with before signing that letter?
So this is what I've said. I mean, not the cases per se, but other petitions.
Yes.
Because I've said that, I mean, first of all, we didn't know that the committee was going to report to the president after one was concluded before the others. And I've said that once they have done their work, I think that the president should have waited to hear the other petitions before taking a decision on it. But then again, I mean, there are people who disagree that if the conclusion of one is this, there's no reason why the president shouldn't proceed. But I think that it was also important that we conclude all the petitions that have gone through the Council of State for her to respond to them fairly. That's my view on it. As far as the other cases are concerned, I do not think that they stay in the hand of the executive at all. In fact, we saw this happen in the election petition. Even though the president, for instance, Nanado was challenging John Mahama's election, he continued to act as president throughout the process, with the understanding that if he were to win, then the president will be removed. In the same way, the institutions must function. And if she is to win, she will be reinstated. That's how it has always functioned.
Some people believe this is a dangerous constitutional precedent, and that whichever government comes in is going to get worse. For somebody who believes in constitutionalism, part of the Mills Constitutional Review team, you should be concerned about this.
I'm very concerned about the way in which the duopoly plays its politics. That's why I've said that there's no office in this country in which they cannot get a person removed. And the constitution will not be an impediment in their way. So I think that if they wanted to do something, they would do it. what we haven't built.
But shouldn't we?
But this is the thing.
We shouldn't constrain them.
Language cannot constrain people. What we can do is that build a counterweight, and that has to be a civic counterweight that makes them, you know.
But don't lend your intellectual muscle to that flawed process. If the duopoly is perpetuating a bastardization of institutions, a brilliant lawyer like you should not be part of it.
So let's be careful here. That one of the things I say is that the normal politicization and the politics can go on side by side alongside rigorous commentary on our institutions and the need for reform of those institutions. If we get into a position where we say that because they fear that other politicians might tamper with the rules or might not act correct, for which reason, even when things are wrong, we should put a flowery dent over them, then we are doing more disservice to how we reform our institutions. We do our work in good faith, in the belief that things ought to act in a particular way, and reform must be done in a particular way. But if they are actors, and we are telling you that the reason why these actors can do what they do is because there's no sufficient social counterweight to them, then we must take that seriously. Because I sincerely believe that we have created a particular political system where no matter what we want to do, politicians can always get their way. I'll give you an example to end on this. When, for instance, there was a whole conversation around Nanado renting the aircraft. And I said we have a kind of politics whereby even if citizens spoke a lot about it, the government can just decide, I'll just buy a new one. And there's nothing you can do about it. So that's where, for me, is more scary about the absence of ways in which we can guarantee constitutional safeguards. The absence of the people rather than the document
So let me use another example. Government has deported 11 U.S. deportees to their home countries. I believe you were part of a case sort of challenging the government of Ghana's role in this. You say a government can do anything it wants, but you still went to court because you still feel like the court could have given the people some succor. So reconcile that for me.
You know what's funny? We had approaches from several organizations and U.S. lawyers, teams of lawyers who are against chain reform, which we are seeing happen pop up across the country. And even as we were going to court within our law firm, many of us were exasperated in feeling that we know how our courts function. We do not believe that they're going to get justice. But we must do something nonetheless. And we went to court. We filed a habeas corpus application. We filed an interim injunction to prevent their repatriation. The judge comes in, the judge says, I don't know anything about habeas corpus, so I think that you should bring this on notice. We are saying that the reason why we're coming as habeas corpus, they've been detained, there's urgency, you have to do this.
So produce the 11.
Produce the 11. She says no. Okay, come back Tuesday for arguments again.
And by the time you come back,
within that Tuesday, we say to the judge that please give an interim order. If not, they're going to remove them. She still doesn't. And comes back the next day, on Tuesday. The first thing she says that Tuesday when she comes, I still think that this application, you have to bring it on notice. Now, we're in legal vacation. But what she's saying, we have to wait till October.
The government has the free hand to do anything.
The government has the free hand to do anything. So we know, and we're talking about this within our firm, that we know that the judiciary does not have the sensitivity even in these kinds of matters. One, the judiciary is afraid of what the executive might feel. She comes to court and says, the first thing she says is that there's so much national and international interest in this that I think that you should bring this on notice. And we say that it is precisely because of those interests that you must be interested in how you stay the executive's hand in such a matter. So sometimes we do things out of desperation, but this is what we have. And many times that we speak about it, I hear people who say that you are attacking the judiciary. So we leave it as it is.
So where should our focus be? Because institutions must work. There must be clear separation of powers. The three arms of government must work with each other. One must not be subservient. So how can the judiciary be salvaged?
I think that, one